have a case in,
Uh-oh.
was that on purpose?
Did we go live?
No, we did not.
Okay. Somebody's recording.
It says you're in practice session, so maybe we're okay.
Yes.
Yeah.
We're just being recorded.
No, just recording, not live yet. Live in 3, 2, and hang on, sorry. 3, 2, 1, live.
Good afternoon, and maybe to some people, evening. This is a Hot Topics presentation of the U.S. Technical Policy Committee of the Association for Computing Machinery, the ACM, being co-sponsored today by the American Bar Association's Criminal Justice Section. I want to welcome everybody who is listening and participating. I understand there are some slides that I'm supposed to be showing. Have they been passed on to me yet? There we go. Thank you. This is the organization we are talking about, the Supreme Court's ruling concerning the Computer Fraud and Abuse Act. The case is Van Buren against the United States. It was decided earlier this month with an opinion 7-2 in favor of narrowing the interpretation of what the Computer Fraud and Abuse Act might be. We are being recorded. This will be archived for public view. However, recorded or not, the event is on background. If you're a journalist, please seek authorization before quoting anybody. The microphones of all the attendees will be muted. If you have any question, you can send a question to me, and I will read it, and we will have the appropriate panelists discuss it. Okay, next. Yes, as long as we are doing this, I hope that those of you who are not members of the ACM will seriously consider joining. It is the largest computer society in the globe and is the oldest computer society in the globe. We have multiple subcommittees, one of which is the Law Committee that's primarily promoting this, and I am the chair of that Law Committee. The USTPC Technical Policy Committee is a group of around 80 people who are preeminent in the area of not only of computer science, but of the policies that are being considered and are in place and should be considered for the future of computing. If you do want to join, please let us know. You see the website number up there, or the website URL, and you'll get an email pretty rapidly, and hopefully you'll join one of the committees that you're particularly interested in. We have multiple ones. Adam? Okay. As I said, I am the chair of the Law Subcommittee, former Assistant U.S. Attorney, and I have my own practice in Washington, D.C. One of the areas of my practice is in internet law and cybersecurity. And of counsel to me in that practice is Mark Rasch, who a noted attorney in this field. He tried the very, very first computer fraud crime case under the CFAA. And he is of counsel also to Corman, Jackson, and Krantz. He has authored numerous, he claims over 1,000, I have no reason to doubt him, articles and blogs on computer security. He also was one of the authors of the Computer Fraud and Abuse Act back in the 1980s. Glad to have him on board. We have Cindy Cohn, who is the executive director of the Electronic Frontier Foundation. She was previously EFF's legal director, civil litigator in private practice. She has also been active in litigation, including the case of United States against Bernstein, which was the first case that narrowed the scope of computer encryption technologies as it's applied. And she can tell you more about that. But I'm going to move on to Alan Butler, who is the executive director and president of the Electronic Privacy Information Center. He manages EPIC's litigation, including the amicus program. I've sat on a number of panels with him, and I'm very glad that he's agreed to participate. And Eric Vandevelde, who is a former Assistant U.S. Attorney in the Central District of California. He headed up the computer crime unit in that office while he was there. He's now a partner with the Los Angeles office of Gibson and Dunn. All right, I am going to move on. We have, let me get this going the way I want it. Okay. This is the Computer Fraud and Abuse Act that we're talking about, Title 18, United States Code, Section 1030. As I indicated, Mark was one of the drafters of it back in the 1980s. And so I'm going to turn this over to Mark Rasch and let him tell us what this statute is about, why it was drafted, what it is and is not supposed to prohibit, and how we got to where we are now.
Thanks, Andy. So the Computer Fraud and Abuse Act was intended to fill in a couple of gaps that were perceived to exist in law as we started to develop computers and computer technology. Prior to the act, we would prosecute people who would steal things or damage things or invade privacy under the common law fraud statutes, typically the wire fraud statute or the mail fraud statute. And unfortunately, lots of these computer crimes were not frauds in the traditional sense of an attempt to steal money or property. The other problem with using ordinary criminal statutes as opposed to a specialized statute is that most of the crimes against computers are not crimes against computers, but they're crimes against information. And we talk about that these days as CIA, confidentiality, availability, and integrity, and you can include within confidentiality, privacy. We do a very bad job in the law of dealing with privacy-related crimes. We don't know how you steal information. We don't know how you possess information. We don't know how you misappropriate information. These are all concepts of property law that don't really apply to information-based crimes. So the idea was to pass a law that would deal with that. And we were trying to deal with theft, destruction, and finally, trespass. There's a physical trespass where you break into somebody's house, you break into their office. There's burglary, breaking and entering, that kind of stuff. There was no electronic equivalent. So the goal of the Computer Fraud and Abuse Act, at least originally in 1984, was to try to fill in that gap. One of the things they did is they said, to get at the concept of trespass, that is breaking in, they used the term access without authorization. And that was intended to try to capture this whole idea of going somewhere, even though it's not a physical location, that you're not allowed to go to. There's also the concept of doing something once you're there. So you can steal information. And it was limited when it was originally passed to certain kinds of information that had other kinds of protections: classified information, banking information, other kinds of trade secret information. Those were protected. So if you broke in and stole that information, you were guilty of computer crime. Over the years, the statute got modified. So the portion that dealt with accessing without authorization got extended to mean exceeding authorized access. So it was intended to get not just somebody who had no permission whatsoever, but somebody who had done whatever it is exceeds authorized access. And it wasn't just narrow categories of information that were protected anymore, but it also included any kind of information. So the statute as modified, now said, whoever exceeds authorized access to a computer, we'll just call it a computer because there's a special definition, but a computer, and thereby obtains information or damages and destroys or things like that, is guilty of a crime. And one final thing to note about the Computer Fraud and Abuse Act is the statute is a criminal statute, but it includes civil remedies, meaning that a person who is injured as a result of somebody else's violation of the statute can bring a civil lawsuit in federal court alleging a violation of the statute. And the reason that's important is because anywhere from 90 to 95% of all of the cases that are brought under the Computer Fraud and Abuse Act are civil cases brought by private litigants against employees, former employees, competitors, whatever else it is, which never get reviewed by a prosecutor and never have the kind of controls that you typically have over a criminal case. It's anytime the civil litigant sees an advantage to bring a Computer Fraud and Abuse Act claim, it's brought in the case. That's what brings us up, and then I'll just give you a very brief summary of the facts of Van Buren so we can see how it applies, and that'll set up the discussion. So Van Buren was a Georgia police officer who had authorized and lawful access to the Georgia NCIC Criminal Information Computer. This is a database of information, including arrest reports, convictions, and the like, that was accessible to him only because he was a police officer. There was an agreement. I don't know whether it was a signed agreement or not, but the terms of access to the GCIC stated that his access to the database was solely for law enforcement purposes. He was working for a number of other different people who had wanted him to get information for them from the GCIC. They paid him to get information from the GCIC. One of the people who paid him was an undercover FBI agent. The FBI approached him, asked him to get the information, not for law enforcement purposes, or at least not explicitly for law enforcement purposes. He was selling information in the database. He was arrested, he was prosecuted, and he was convicted for violating the Computer Fraud and Abuse Act by exceeding his authorization to access the GCIC computer. The 11th Circuit, which is the circuit that covers Florida, which is Georgia, which is where this happened, ruled that he had in fact exceeded his authorization. He was only authorized to access the database for law enforcement purposes. He exceeded his authorization to access it and therefore violated the statute. And the question for the court was, is there a distinction between, number one, accessing with authorization, in other words, you're using your real legitimate user ID and password to access the data, but then using that data for a purpose you're not authorized to do it. As you access with authorization, get information, and then do something you're not permitted to do with that. And what are the implications for that? So most of the time when we're on the internet, we agree to terms of service, terms of use, and we agree not to do stuff, or we agree to do certain stuff. When you violate those terms, anything from putting in your incorrect name, height, or weight on a website to abusive language, are you exceeding your authorization to access a computer and therefore potentially subject to criminal sanctions? So that's where we are. A couple of cases to deal with, real simple. NoSal dealt with a bunch of employees who are former employees, went to a current employee and said, hey, can you get us this data? The current employee downloaded data from the employer, gave it to these people who used it for competitive purposes. The employee, who was the current employee, used her legitimate user ID and password. And the question was she exceeding the scope of her authorization because she was getting the data for people who weren't entitled to it? And the other case, do you have HiQ on here, Andy?
No.
The other case involves LinkedIn and HiQ. And this is a case that was not yet decided by the Supreme Court, and they remanded it. But LinkedIn has all the data you know of it, and LinkedIn. HiQ was scraping the data from LinkedIn and selling the analyzed data. LinkedIn said, stop. There we go. So HiQ said, stop doing this. LinkedIn said, stop doing this. HiQ said, we won't. And that was the question, is whether they were exceeding their authorization. That's where we were in the Van Buren case.
All right. All right. So what was the major issue in Van Buren?
Well,
Me?
yes. Cindy, you want to do that?
Sure. I mean, I think that the kind of fundamental problem with the CFAA is that it makes it improper, it makes it illegal and even criminal for you to have unauthorized access or exceed your authorized access. But the statute does not define what authorized means. And so this is where the fight is. Are you not authorized when, in the case of the officer in Van Buren, when you had permission to access the information, but limits on your ability to use it based upon, you know, worker limitations, or does there have to be something more for you to be unauthorized? And the 11th Circuit had said, well, you know, the terms of his, you know, contract or his work term said that he wasn't supposed to use it for, you know, figuring out whether somebody was an FBI informant, which I think was the sting operation that was going on. And so therefore he was not authorized. So therefore he can be criminally prosecuted under statute. And the Supreme Court said no. Supreme Court said, we're going to look at this, first of all, and I think one of the core things about this is we're going to look at this the way computers and technical people look at this. We're not going to use, you know, Merriam-Webster's definition of authorized. We're going to look at what these terms authorized and access mean in the context of technology. And this is a point of disagreement between the majority and the dissent. And they basically said, we're going to look at authorized as what they call a gates up or down approach. Were the gates up such that you could go in as our officer could to the database? There were technical limitations. The limitations were just in his, you know, arrangement with his employer. They're not technical. That's not enough to make his access unauthorized. Now, the court did drop a footnote and said, well, we're not saying it's purely technical. We're not going to say exactly what it is, but this wasn't enough. And of course, we're going to be talking about footnote 8 for a really long time about what that actually means. But that's, I think, the nub of it is what does authorized mean in the context of this statute that turns liability on authorized. And the Supreme Court said, you know, merely doing something that somebody doesn't like on a computer is not make you unauthorized for purposes of this CFAA statute. And you know, the court, we were very happy that, you know, EFF has been saying for a long time that, you know, when you think about how the internet works, you're on somebody else's computer all the time. As Mark pointed out, we click wrap and, you know, the contractual and other limitations on what we're supposed to be doing are pretty asymmetrical and not really understood by people. You know, I think when we did a research, we found out that if you went on the website of 17 magazine and you were 17, you actually violated their terms of service because you were supposed to be 18 to access the website because that's what they said. Now, this is the kind of thing that should not engender, in my opinion, any liability, but certainly shouldn't trigger a criminal statute. And we were very happy to see that the majority opinion, Judge Barrett, points this out and says, you know, so much innocuous activity on the internet would be rendered criminal by us adopting the government's position that anytime you break any contractual or other thing that you know you're not supposed to do on a computer, you're potentially creating criminal liability. And I before I yield the floor, I think this is really important. I know we had this as an ACM event, and you know, EFF has partnered with this committee and the ACM a lot, trying to explain technology to courts. One of the areas where I think this is going to be really useful is security researchers. A lot of the work to make the internet safe right now is done by independent researchers, where you're talking about the Heartbleed or any of the huge number of major security problems have been unearthed by people who were digging around in other people's computers that the rest of us rely on, and figured out that there were problems there and they were rendering us unsafe. And so the standard for holding a security researcher liable for that kind of behavior has gone up a lot as a result of the Van Buren case. Again, I wish there had been a couple brighter lines in that opinion, but it's clearly signaling disfavor, and also signaling disfavor with the idea that we could make it potentially criminally liable and just trust the prosecutors not to bring bad cases. They expressly rejected that, which is really good news. As somebody who advises security researchers all along, the least comforting thing you can say to somebody is, "Don't worry, they probably won't prosecute." So those are some of the things. I can say a lot about this opinion. EFF has been working to get the clarity out of the CFAA since, in the whole 21 years I've been at the EFF, we've been working on this. So we were pretty happy with this decision. There's more road to go. It's not my dream decision, but it really clearly rejected some of the core arguments that we'd seen made over the years, including some really awful injustices. So that's kind of my view. I'm happy to talk a little more. I know my dear friends at Epic, we disagree with each other on this case. So you're going to have a rare situation where you have the civil liberties community feeling differently about a case.
Yeah, this is one of the things that really surprises me. That on the one hand, you have EFF supporting Van Buren. On the other hand, you have another civil liberties group represented by Alan Butler, Epic, who was supporting the government. And I'm trying to get my head around how two electronic civil liberties organizations can be so far apart. Alan?
Sure. Well, thanks for having me, Andy, and everyone at ACM, and to everyone else on the panel for having me here. I think that, in some aspects we're far apart, and in some aspects we're not, and it really kind of depends a lot on the type of cases we're talking about and the type of circumstances. I think that everyone probably on this panel, or most people on this panel, probably agree that there need to be substantive limitations on the scope of the CFAA, right? I mean, in particular, the 1990 amendments, which broadened the scope of the type of information protected, really made the statute incredibly broad. And I think that there's been a struggle for decades to figure out exactly how to scope it back. But the question is, where do those limitations come from, and what types of cases do they apply to? And one of the reasons why Epic got involved in this case in particular, and why we filed in support of the government at the Supreme Court level, is because this was a case involving the abuse of a government agent of a protected database that contains sensitive personal information, which we feel is at the core of what the CFAA is ultimately about. And one of the things we highlighted in our brief is, and I totally recognize that there is risk and have been real cases of misuse of the CFAA in the overbroad sense, but there are also many documented cases of misuse of government databases that have significant implications for personal privacy, which we talked about. I mean, I think Van Buren is a quintessential case that we talked about in our brief as well, a number of other circumstances and situations where there have been reports, including in the state of Colorado, out of Denver, of widespread abuse of misuse of databases by police officers in general that have gone essentially under enforced. So that's what brings us to this case. And I think what's really fascinating about the outcome and what happened is that the Supreme Court ultimately really didn't answer many of the questions here, right? They explicitly in footnote 8, they don't answer the fundamental question of, are they going to scope this based on technological restrictions being a bright line versus contractual or other policy restrictions being a bright line. Instead, they just essentially kick the can down the road by saying, well, what matters is whether the gates are up or down. They don't explain what it means for a gate to be up, or if a gate has to be always up or always down, or whether it can be turned on and off, whether there could be a policy that essentially says you can access the license plate reader database during your shift hours, but not off hours, or whether it could say you can access the license plate reader database if you enter a matter number for an investigation that you're involved with, but not if you don't, right? I mean, there's lots of examples that you could give that would fit within the rubric that the Supreme Court majority laid out, that I basically think means a lot of these questions just shift over to a question about entitlement or authorization. And one of the things we highlighted Epic highlighted in our brief was the fact that if you're going to reach to a set of norms to decide how to narrow the scope of the CFAA, we think that should be informed by its underlying data protection purpose, because as Mark mentioned, the roots of the statute really were growing out of a number of statutes aimed at protecting personal data, obviously confidential and classified information as well. But a lot of the abuse cases, I think, are situations that really aren't people trying to access or misuse, get access to misuse sensitive information, but are just people sort of using a platform, right, or using a website, or getting material from a website that's otherwise publicly available.
Okay. All right. I do have a question for you, Alan, before I move on to Eric. I think you've taken the CFAA and you're trying to use it as a privacy law. And I don't see the CFAA as being a privacy law. I see it as a means of protecting data in a computer and perhaps hardware in a computer. But you're taking one law, trying to use it in another way by stretching the language. And does that not pose civil liberties concerns to people who maybe find themselves on the receiving end of a prosecution because they did something that was not the purpose of the protection of the statute?
Alan, it may also implicate whistleblowers as well, who access it for one purpose and use it for a different purpose, albeit one that's
I'd like to
it's
give
not just
Alan-
implicate. I mean, there's CFAA charges against Chelsea Manning and there's CFAA charges against Edward Snowden right now. This is absolutely a tool being used by prosecutors against we can fight whether they're whistleblowers or not, obviously, but I don't think the CFAA is the question. The question about whether you decide they're whistleblowers at the end of the case isn't actually relevant to how you charge them at the beginning of the case. So it's absolutely being used against people who are whistleblowers, and I don't know if it was used against Reality Winner, but I tend to think it was. If my memory of the charging, no, okay. In any event, it's not just. I mean, I think you're being kind in the implication. Like this is a situation in which prosecutors have used this statute in all of the ways that we feared, and of course, for me, and there's a question I saw in the thing about Aaron Schwartz, my friend, who tragically took his life, but facing tremendous CFAA charges for something that I think would actually not survive as a prosecution after Van Buren, given the open nature of the network that he used. So anyway, I'm happy to talk about that a little more deeply, but again, this is, I'm sorry, I didn't mean to jump in, but this is the nub of our difference between EFF and EPIC on this, is that I am very much in favor of a very strong privacy law. We really need it. And I understand the desperation of my dear friends who focus on privacy to try to find something, anything to help people protect people's privacy, but this shouldn't be it.
All right, I am going to get to Eric, I promise you. But I need to let Alan defend himself.
Sure.
If he can.
So I think that you heard from Mark in the beginning that this is a and even you mentioned, Andy, this is a statute about protecting data, right? So I'm not trying to represent that this is somehow a comprehensive privacy statute, but it's a statute about protecting data. And what we're ultimately arguing about is what is the scope of that statute. And part of the interesting thing about, the examples that we've just been discussing about whistleblowers or researchers or otherwise, is those examples don't break down on whether the restriction is technical or a contractual restriction. There are independent researchers, there are legitimate researchers, there are whistleblowers who may circumvent technological restrictions. And if so, they're violating the CFAA anyway. So it doesn't actually answer the question ultimately. And part of what we were trying to focus on in our brief is to say, look, if we're going to impose norms in this process, which we ultimately have to because the statute is so broad and courts don't know what to do, then bring this set of norms to and look for cases that do actually involve abuse of data, like what Van Buren did, which was ultimately an abuse of a sensitive data system.
All right, we are going to Eric, as I promised.
Yeah, this discussion is interesting. I mean, I view a lot of this from a big picture lens of who has the power and who's setting the norms. One kind of dynamic I want to convey. I was an AUSA, but for many years now I've been in the private sector. Some of the people setting the norms are plaintiffs' counsel in private civil context, and they are pushing the envelope further and further and further I looked up some statistics in the past few years. CFAA claims have been going up by 30% a year. And as Mark pointed out, 90 to 95% of all CFAA cases are not the criminal prosecutions we're talking about. They are well-funded private litigants suing companies, often as class actions. Often it's with what I would consider an anti-competitive purpose. And so what you have is a system in which corporations, through terms of use, through revocation letters and cease and desist letters, are able to shape the landscape of what is and is not a crime, which, you know, personally, it's somewhat terrifying. And so I think what Van Buren is trying to do, and I agree, a lot of questions are not answered, but I want to get to one thing in a moment. What I think it's trying to do is ratchet back the outer bounds. They didn't resolve the big issue about whether a technological barrier is required. The thing I wanted to touch on just really briefly is about this notion of privacy versus kind of data protection. I mean, at its core, these cases were Mark should tell us, but they were anti-hacking statutes. They're not about privacy. That's the origin of them. And I thought the court in Van Buren did something really interesting. I actually have a case that I need to argue next week about this very issue, which is that the Supreme Court majority opinion said that in the civil context, there needs to be a technological harm to the system. And they talked about it in terms of file corruption or harm to a database. And they seem to at least rule out the possibility that the technological harm they're talking about is the mere obtaining of otherwise, quote unquote, private information. There has to be some kind of hacking type harm. And so they didn't go all the way there, but they strongly suggest that that is one of the ways that they're going to ratchet back kind of the scope of this law and really tether it back to its core of anti-hacking, which is, you know, hackers breaking into systems and causing damage in the way that Justice Barrett kind of laid out.
I've got a jump ball I'm going to throw out here. Whoever wants it can grab it. One of the big issues in Van Buren was the prohibition against exceeding authorized access. So you have accessing a computer without authorization, and you have accessing a computer with authorization, but you're exceeding the authorization you have. Why was that second prong put into the statute? What does it mean? And have the courts been getting it right or wrong?
Well, I can jump in there as to why it was put in there. So it started out with access without authorization. We had a few prosecutions under that particular statute, but that meant a complete outsider. What that meant is if I work for a company and I have an email account or whatever and I can access, but I'm not allowed to go into the HR department, and I break into the HR department and steal everybody's personnel file, well, I didn't violate the statute because I had authorization to access the computer, whatever that means. And therefore, I'm okay. And it actually arose out of a case out of the First Circuit called United States versus Kubinski. And Kubinski was an IRS employee who also worked, I think, either for the Klan or the Nazi Party, and was using his access to IRS databases for the benefit of the Klan, either to embarrass enemies of the Klan or whatever. And he was prosecuted under a wire fraud theory because they couldn't prosecute him for accessing the IRS database without authorization. And he actually won the case, Kubinski did. That was part of the testimony that convinced Congress to expand the statute. Now, interestingly enough, that's not all that much different historically from what it is that Van Buren did. Access the database he had lawful access to, but for an illegitimate purpose. So you can actually make the argument that when they expanded it, this was exactly what they were trying to get at. The problem was what they didn't anticipate is the advent of these contracts, these terms of service, these terms of use, whereby if I watch a sports game, if I watch a baseball game on my work computer, I violate the employer's terms of use and I have exceeded my authorization to access. Or if I open a MySpace account in the name of a fictitious person in violation of the terms of service of MySpace, then I am therefore exceeding the scope of my authorization. And one of the things that the court did in the Van Buren case, without setting a bright line, it says, wait, just violating terms of service, just violating terms of use, that makes criminals out of everybody. That's not what the CFAA does. So you can turn back and say, okay, so what does it do? So, well, we don't know that. We just know what it doesn't do. It doesn't do that, and it doesn't prohibit what Van Buren did, but we don't know what else it does.
I mean, I think I largely agree with Mark. I think the difference between unauthorized access and exceeding authorized access does turn on insider, outsider. But I think exceeding authorized access under the gates up or down thing recognizes that even once you're in a computer, there are gates. And to me, the difference between what Van Buren did, I'm not sure, I don't know the Kaminsky case, but the thing that Van Buren did was he did the exact same thing he did in the scope of his work. He just did it for a bad purpose. So he didn't jump a gate, right? If he had jumped to the HR department and taken stuff out of there, then I think we'd have been talking about exceeding authorized access. But within the scope of what he had authority to do was to run people's license plates.
Yeah,
It's just, he did it for a bad purpose. He did the same thing for a bad purpose that he could otherwise do for a legitimate purpose. The gates were up for him.
And that's what, that's what gets into this location versus purpose and what are the gates. I mean, if you have access to a computer, the court talks about folder X versus folder Y. You could take, that to the nth degree, and there's 1,000 folders, and you could do it at a file level, you could do it at a network connection level, you could do it at a folder level. And so what does it mean? So it's really about what does access mean, and is a technological barrier required? I mean, if you have the technical capability to access every bit and byte on a system, but you're only supposed to look at certain ones, one in folder X, have you violated the CFAA? And I think the court left that kind of wide open. But the hints are that I think they would have a more kind of searching inquiry as to whether a pure policy or pure terms of use based approach would survive.
And Eric, just to point out, I just want to point out something with Eric about how the implication for security researchers as well. We'll let Alan jump in a second too. So, for example, some of the early security researchers, they would have a URL which would have a particular folder, and they would truncate that folder, add a different folder, add a different sequence, and say, "Oh my God, look, I can see all this other data," which led to this assumption among hackers and security researchers that if I can get somewhere, then I am allowed to get there, because you either had no barrier or such a weak barrier that I was able to walk in, what you might call either the open doors exception or the unlocked doors exception. And the problem is, this isn't the real world. Those analogies fall apart. We don't know where the lines of demarcation are between where you're allowed to go and where you're not allowed to go. And therefore, the requirement for some technological barrier serves a couple of functions. It's a no trespassing sign where there are no trespassing signs. So it's necessary to establish knowledge, intent, and all that stuff. But it's also knowledge it's required to establish this whole concept of exceeding authorized access. It is the gate up or gate down.
Yeah, I mean, I think that ultimately there's a couple different threads of where these cases will probably go. I think that there's a looming fight in HiQ versus LinkedIn, which I'll talk about a little bit also, that is significant in the potential for abuse of the process that's different from what we've seen before in CFAA cases. So to unpack HiQ versus LinkedIn a little bit, and I think this gets at the kind of open access versus data protection norms that we're grappling with, Eric was grappling with in our brief in Van Buren. You have, I mean, it's not a story about white hat or even gray hat security researcher. It's a company that's trying to monetize user data, right? And LinkedIn didn't sue HiQ. Yeah, they sent them a cease and desist letter, but they also imposed a bunch of technological controls to limit HiQ's ability to scrape user data from their profiles. But ultimately, HiQ sued LinkedIn, and convinced the district court to issue a permanent injunction. It's a very crazy case. They issued a permanent injunction that not only prohibited LinkedIn from, made them withdraw their cease and desist letter under the CFAA. Okay, it prohibited LinkedIn from imposing any technological measures to limit HiQ's access to the data. It literally said the gates have to be up. You have to let this company scrape this user data, even though LinkedIn provides a feature for users where even if your profile is publicly searchable, you can have a do not broadcast feature. And the purpose of that do not broadcast feature is to make sure that any updates you make to your profile aren't broadcasted to the world. Well, guess what HiQ does? They build profiles of employees and they sell a service to their employers to say, hey, when your employees start updating their profile, they might be trying to leave. So we're going to let you know so that you can act accordingly. So HiQ versus LinkedIn is not a security researcher case. It's not a sort of like edge case I think it's a hard case under the CFAA, but what's really shocking about it is that the injunction, which is not only limited to the CFAA, is really imposing open access on a platform that ultimately has obligations to their users, right? And their users are kind of left to flail in the wind here. So I found that case to be really shocking for that reason. And I'm very interested to see what happens on remand, not just with the CFAA question.
All right.
I mean, I completely disagree about HiQ. Not
that was going
surprised.
to be my question of you, Sandy.
Yeah. We've supported HiQ from the beginning of this. First of all, it's public data. This is information that LinkedIn
Publicly accessible data.
It's publicly accessible data, and LinkedIn sells the same service. So this idea that somehow LinkedIn was giving you the chance to not tell anybody if you were updating your thing. Yeah, LinkedIn gave you the chance to not tell anybody but LinkedIn, but they still sell the service. So this is somebody who wanted to build a competing product to a product that LinkedIn serves and use public data to do it. And what the Ninth Circuit said is public is public. You don't get to say this is public except for my competitors. You don't get to
Cindy,
do
how do
that.
you deal with then by scraping face images off of Facebook and selling facial recognition analysis of all those images? It changes the character of the data depending on, so Facebook can say, I was just listening to something about Ring today. They're saying how Amazon doesn't use those images and won't use facial recognition on those images. But they don't say that we won't make the databases available for third parties to add facial recognition. So,
yeah, well, we've been beating up on Ring more than anybody, and we certainly beat up on Clarity. But what this points to is the need for a privacy law, right? Again, interoperability is important. Scraping for purposes of interoperability is important. We're living in a world where we've got 4 or 5 big companies that have all the data, and they're leveraging that in ways that I think are very harmful to society. So interoperability, we call it competitive compatibility. Scraping is a piece of this, is some of the way that we get ourselves out of the basically surveillance business model of the big tech giants. We need privacy law, but trying to, if we allow the Computer Fraud and Abuse Act and other, I agree completely. I mean, I don't call it hacking, I call it breaking and entering. But if we start using breaking and entering law as a substitute for privacy law, we are giving more power to the people who have all our data, and we're making it harder and harder for someone else to compete. And again, HiQ was trying to build a competing service to one that LinkedIn already offers, and LinkedIn doesn't let you opt out of that service.
Yeah,
So if it's to me, it's a very different situation. I am all in favor of empowering people around privacy, but using a criminal statute like this, and one that is anti-competitive to boot, to do it, is going to keep us in a bad place rather than help us get out of it.
Eric?
I was just going to jump on that anti-competitive point, because I mean, let's not kind of be naive. I mean, multi-billion-dollar companies have terms of use. They reserve the right to change them whenever they want without notice. And I'll leave the companies out of it, but a multi-billion-dollar software company who changed the terms of service to prevent third-party repair of their software by basically saying that one third-party service provider cannot access their systems to download the patches to help that third-party service provider provide the patches and help them implement these patches on their systems. So just to drive home the point, companies are using the CFAA and terms of use and revocation letters, meaning banning people from touching their websites, as weapons to squash competition. And I don't have the solution, but I do think it's going to lead to a bad place if the statute can be weaponized that way.
Yeah, and I don't want to we tried to write a law to reform the CFAA after Aaron Swartz died. It's called Aaron's Law, and it was squashed by Oracle because Oracle got one of the largest civil judgments ever using the CFAA against somebody who was an unauthorized repair person. So again, these aren't theoretical, civil liberties, people up in arms about competition situations. This is actually what's happening on the ground with this law because it was not reined in. And I think that the Supreme Court did a good thing. They didn't go far enough. We're going to have more litigation, but it is tremendously important. When anybody sits down to me and they say, oh, I want to build a cool new tool to let you look at your social media feeds better, like a company called Power Ventures did, right? I say, well, you're going to have to deal with terms of service. You're going to have to deal with a criminal law, the Computer Fraud and Abuse Act. You're going to have to deal with Section 1201 and the anti-circumvention things. And if you can make it all the way through that, well, maybe you can innovate. That's not the kind of space that I think we should be in with regard to innovation.
I have a question.
How can people control who has access to their data on their database and for what purposes? I mean, if you look at the Schwartz case, right? What could MIT have done if it really didn't want Aaron Swartz to do what he was doing? They kicked him out multiple times. They told him to leave. He literally broke into a closet and put a computer in the closet to download the data. What could MIT have done to limit the access or use of that particular data, assuming it had a right to do so?
MIT had an open campus for access to JSTOR. Anybody who was on campus, on the physical campus, had entered town. They assumed or made this presumption that only people who were on the campus were the ones who could do that. Aaron went to the campus and he downloaded things. And he downloaded more than they wanted him to. They could have said, your student ID number gets you in. And Aaron didn't have a student ID number. He wasn't a student at MIT. He wouldn't have been able to, but because they cut corners around their security. And indeed, this is one of the things that I think adding the technological limits and other things on it does is, the idea that you shouldn't have your whole website available on the internet for a search if you just truncate the end. You should put real security on your data. And that real security not only helps in terms of, actually protecting the things you say you're protecting, but it puts everybody on notice what's in limits and what's not in limits. Now, all they had to do was make you have to log in with your student ID, and then MIT, I think, would have had a different situation with regard to Aaron than the one that they had.
All right, I'm going to add
in the statute itself was this whole concept. Just 1 second, Andy, I know.
Yeah. We've been through this
whole
before.
Concept that you need to if you haven't done enough to keep me out, I'm allowed to get in. Now that wasn't the Aaron Swartz case, but this is whole concept.
No, it's not the Aaron Swartz case.
The Robert Morris case, which is the one I prosecuted, one of the issues was what was he allowed to do and what wasn't he allowed to do? At what point did he access without authorization? At what point did he exceed it? So one of the things he did is he sent what you call a mail bomb through SendMail, okay? And he said, one of the arguments he made is, since I'm authorized to send mail, even though the mail destroyed information on your computer, I didn't access your computer without authorization. I was authorized to send you mail. I wasn't authorized, and that's one of the other reasons why they added the exceeds authorized access.
All right, I want to say one thing about Aaron Swartz, and then I have a question that dovetails to something I want to ask Eric. And what I will say is, if you read the MIT internal investigation report, there is a footnote, and that footnote recites the comments of 5 IT professionals at MIT about whether or not Aaron Swartz had the authorization to do what he did. And you have to realize that MIT is a technological institute. Its purpose is to train people to be not only technologically proficient, but creative and encourage their curiosity. With that as the background, those 5 IT people said the following. First, one said, no, he did not have the authorization. A second said he may or may not have. The remaining 3 said he did have the authorization. And I kind of wonder why Those questions were not asked before that case was brought, and what the result would have been had that evidence gotten to trial. And with that, I'm going to go to Eric and say, why was the CFAA used in this case, if you have an opinion, meaning Van Buren?
In Van Buren, or you mean the Schwartz case?
No, Van Buren.
I
And
think
if you want to talk about Aaron, go ahead.
no, I don't have any. You guys know that case better than I do, having lived through it. I mean, I think the Van Buren case, if I'm putting myself back in the, wearing the government hat, being a supervisor, those facts coming in, it's egregious facts. You have a trusted public servant with access to what we would all agree is a very sensitive database with information that should not, it is a deep violation of public service and law enforcement service to do what Van Buren did, to sell information to an informant. And so I think the thinking is we need to find a way. They charged on a services fraud, that got reversed as well. And so, they didn't want to have an answer of there's no tool in our tool shed to be able to get at this conduct. Now, there's a strong argument to be made that if you're a supervisor of that police officer, Van Buren, and you find out, you just fire him and look, his career is over as a law enforcement officer, and that would have been punishment enough. But it is, I don't think it is unreasonable for law enforcement to do a searching inquiry to see if they can find a statute that fits the bill. We also have to be mindful that in the 11th Circuit, they took a broad view of this. Under the 11th Circuit law at the time, before the Supreme Court's decision, this was a viable charge. And so I think that's what was going through their head when it came up the chain.
And
If you look at the Denver report that Epic cites in our amicus brief, also you'll see that this is not unique to one police department. I mean, there have been widespread similar problems, and one of the things they found in the Denver report was that basic reprimands and minor fines were not sufficient to deter the behavior. So, what is?
And Andy, in similar cases, they've used 18 U.S.C. 641, the embezzlement statute, which presents its own problem. The concept that you steal information, that would mean every time you left an employer, particularly a government employer, and went to work somewhere else, you have in some sense embezzled the knowledge that you have with you. So the idea of embezzlement of information, knowledge, particularly when applied to publicly available information, is even worse than trying to use the Computer Fraud and Abuse Act.
All right. As I think all of the panelists know, the ACM submitted an amicus brief in this case. And we did not take a position. It was a neutral brief. But one of the things that we tried to point out to the court was that, and this is an analog to what Cindy said, that you're always on somebody else's computer when you use the internet. Actually, everybody else's computer comes to you. Because as I am sitting here in front of my computer, what's happening is all the information on your computers that enable me to see your pictures and hear your voice come to me. So the question is, if I'm looking at something, what's the difference between looking at it and downloading it if all we're talking about is authorized access? Mark, you were on the brief.
Access was defined in the case law as to use the resources of. So even if I ping your computer, I've accessed it. It's extraordinarily broad. And one analogy is the definition of computer is so broad that if I cook a tuna fish sandwich in your microwave without your permission, I have accessed a computer without authorization or in excess of the authorization.
Especially if it's an Internet of Things microwave. But go on.
What's that?
Especially if it's an Internet of Things microwave. Go on.
Right, but even if it isn't, because the chip in the microwave is a computer.
Yeah.
And so the statute, number one, is incredibly broad because of the nature of the technology. But number two, it's also incredibly broad because of the nature of trespass law itself. And there was a case a number of years ago in Reston, Virginia, where this guy had a smartphone, one of the early smartphones, and he was in the Best Buy in Reston taking pictures of prices and then using his access to go on the internet and look up prices. And they kicked him out of the Best Buy. And they arrested him when he refused to leave for trespass. All right. And all he was doing is doing price comparisons. And the argument was, once we ask you to leave, if you don't leave, you are trespassing. And that's high Q. That's the cease and desist letter. And the real problem is trespass law is incredibly broad. And when you take an incredibly broad area of law and then use it by analogy to a circumstance where it was never intended to be applied, you end up with a broad law and an incredibly broad application. And this Van Buren was some minor attempt to rein that in.
We have several questions, and some of them I think have already been answered in the conversation, but I'm going to pose them again and make sure that they have been answered, and perhaps some of the panelists have some additional information that they'd like to opine on. One of our anonymous attendees asks this: privacy violations are very often arise in situations where access is definitely authorized, but the purpose is improper. For example, checking medical records of a social acquaintance. How do today's laws deal with this purpose in this context? Alan, you're the privacy guru here. No disrespect intended to Cindy.
None taken.
Well, I mean, look, there's been a discussion earlier in the conversation. I certainly agree with that. We're in dire need of updates to our privacy law in the United States. We at Epic are the first to be on board with that. And the reality is that because of the lack of action for many, many years and over decades to update our laws, there are a lot of areas where misuse of personal data are not covered, right, by the law. I think the CFAA, even after Van Buren, certainly covers some situations in which data is being improperly accessed. Everyone on this call at least agrees to some degree of, if someone hacks in to, if someone hacks into your iCloud account and steals intimate images, that's a CFAA violation in some set of facts. I think everyone probably agreed to. But where that line is drawn is going to depend in the future, in these cases, on how courts interpret what Judge Barrett's opinion says about gates up and down, files and folders, what it means to be entitled to access something. So we don't know the scope of the CFAA in this context, but in other contexts, in the U.S. for now, you have better rights if you're in California than if you're in various other states now, all of a sudden. Otherwise, at the federal level, you're kind of stuck with a bunch of sectoral laws, or you have to go to the FTC and convince them that the company is outright lied to you or is engaged in some very nefarious, unfair practice.
Else? All right. One of the questions, this falls right within the decision of Van Buren. But the question is, current criminal justice information service policy, specifically that pertaining to accessing criminal histories and disseminating that, seems to be contingent on authorized purpose. And how does this relate to Van Buren?
I'll jump in real quick. Is there a meaningful distinction between saying you may only access this database if you use the data for X purpose, or you may access this database but only use the data for X purpose? And I don't think that's a meaningful distinction. I think you're either authorized to access the database or you're not. The purpose limitations occur after you've already either authorized access or unauthorized access. I could see a court splitting hairs there, but I don't think after Van Buren that would be successful.
I agree.
All right. This is a question that I posed a couple of days ago. We discussed it when we were meeting together in preparation for this. Why was this case, Van Buren, brought in federal court? I mean, we have a state court police officer using a state database, and he's being investigated by the FBI, and he's prosecuted in federal court instead of state court, where maybe there was a law that was more appropriate and easier to use for the prosecution. So why are we in federal court? Why did we ever get this case up to the US Supreme Court?
Well, there's the practical answer is they probably call, the FBI was involved. So the practical answer is when the phone call is made to law enforcement and law enforcement is the FBI is going to go to a U.S. Attorney's office, as we all know, and it's going to be a federal case. The legal answer is the breadth, of the CFAA in terms of kind of jurisdiction. Federal jurisdiction is massive. If there is a computer and it touches the internet and then it can essentially be, information is obtained, then it can be brought in federal court. So the scope kind of jurisdictionally of the law is very sweeping.
One quick thing I would add that relates also to the previous question about CJIS policy. I think there's a couple really interesting examples in Justice Thomas's dissent in Buren that are worth thinking about in relation to that question. So 3 he gives are, take an example of a computer technician who's brought in to repair a celebrity's computer, and while repairing the computer, they go outside the scope of their repairs, they find personal photos and they leak them to the press. Second example he gives is if you're an employee of a defense industry entity, and there's a rule that says you can't log on to the secure system from essentially an unsecure network. I think he used the example of an unsecured country, and then you log on, and as a result, the outsider gets access to the system and gets access to the data. And then the third example was on the flip side. I think in the gates up or down by folder category, if an employer prohibits employees from playing solitaire, you cannot access anything in the games folder. That fits the description of what Justice Barrett talks about in terms of a gate being down for a folder. And is that then a CFAA violation anyway? So I just thought those examples were interesting.
First one, of
I mean, my
course, is-
perspective, yeah. I mean, my perspective on those is that the CFAA is a bad tool for most of them. They're not breaking and entering scenarios, and breaking and entering is, I mean, again, one of the things Supreme Court cautioned us against is real world metaphors. So I apologize, I'm breaking that caution here. But the difference between these is, to me, that question. And the repair person one is the one that is, I think, the most difficult, because you don't know ab initio where you might have to go if you do this. But certainly law enforcement, I mean, people taking their computers to Best Buy and having law enforcement turn them in for what's found on the hard drive is something that we've been concerned about all along. If I put on my other hat, I'm like, I'd love to have the CFAA for those situations, but that's not actually how it comes down. So.
But it raises the whole question of whether you can authorize somebody to access for one purpose and not for another purpose. If I take my laptop to Best Buy, could I say, here, you may do this, but don't look at this folder. That's where I keep my child pornography. Don't look there. You know what I mean? I don't think you can do that. I think they're either authorized or they're unauthorized. The concept of exceeding authorized access, I think I agree with Cindy here, that that's a blunt instrument to get at what might be a privacy violation. And part of the problem is exactly because we're all dealing by analogies. You may come in my living room, but you may not come in the kitchen. Computers don't work that way. It's not like there's a physical place. And one of the problems with Thomas's dissent is he keeps talking about property. Digital information is a unique species of property. It's not the same as a desk, a chair, a table, or a room.
Well, and that ties into an earlier point that I think Eric raised about the discussion in the case about technical harm. I mean, one thing that I think is a little bit concerning about that, but though I understand the points that raised about it, is that there are going to be straight up breaking and entering cases where, like my example of hacking the iCloud account and taking in images, that otherwise would be fully within the scope of what the statute is about. That's a digital breaking and entering. But stealing, downloading the information, just downloading the information is not if that's not considered an eligible harm, then you're just out of luck, basically.
And these information crimes, we typically talk not about the theft or the downloading, it's the use, the improper use, the misappropriation. So we have these concepts of misappropriation in copyright, in trade secret, in patent, that kind of stuff, the misuse of the information. That is a much closer thing to what you're talking about in the privacy area. It's not me seeing it, it's me improperly using it. A part of the improper use could be my seeing it. If I break in and steal naked pictures of you, I don't have to broadcast them on the internet to create a violation. But yeah, we didn't have that concept when we wrote the statute of merely viewing.
I mean, I think Alan raises a really good point, and it's a really good point about why we need to think a lot about privacy harms differently in this country. Again, I still don't think you should graft it onto a breaking and entering statute, but I do think that we have, and this gets into a whole other conversation we can have about the Supreme Court's jurisprudence and the lack of recognition of the power and the harms that come from privacy, or even the standing that one has if a privacy problem. I mean, we've got a lot of work to do in that other area. And as I said, I have all the sympathy in the world. And even, on our team, like there's a hammer out there. Can we treat this problem like a nail? And the CFAA is a pretty big hammer. And I think that we still have to be careful about it. And I think that the question, I think that this damages and the damages having to be technical things is another clear indication that this tool just shouldn't be a privacy tool. It's not going to be able to be used as a privacy tool. I don't think it should have been used as a privacy tool, but it's not going to be able to be used as one going forward, at least not until we have a better understanding of the value of people's privacy and how we're going to do that, whether we go the copyright route and we have statutory damages, right? Nobody, people in copyright claims don't have to prove harm. They get statutory damages, or the way that we do that in wiretapping as well. It's not just in copyright. That's one way that we think about problems where damages are hard to prove. There are other ways we can think about things where damages are hard to prove, but this is work we have to do if we want to protect privacy. And I think the Van Buren case makes it clear that this statute isn't a good fit for that problem, and it's even going to be a worse fit going forward.
Eric's point is well taken, that the person wielding the hammer is typically a multi-billion-dollar corporation, not a prosecutor trying to protect some public interest.
Yeah, but Alan, your point, I think it's a really good point, and I wasn't in the room when the case was decided by the justices, or in the room with Justice Barrett while writing it. I wonder about her comment though about technological harm. I do think it could potentially be used to carve out what I think we would all consider is kind of true hacking, true breaking and entering. When you have a sophisticated, Russian or Chinese state-sponsored hacker attacking a U.S. corporation systems and obtaining information. All they're doing is just obtaining, maybe even just looking at it and not even extracting it. I think we'd all agree that is hacking. And so it'll be interesting to see what becomes of that statement. I already have opposing counsel saying it was just dicta. It doesn't mean what she wrote. It's not really technological harm. Obtaining the information is enough. But I'm not so sure, because other things in that opinion suggest a real kind of narrowing, even if they left open other unanswered questions.
Another quick thing that was inspired by something Cindy raised, which is, talking about this harm in the context of privacy. A lot of that conversation recently, the Supreme Court focus has been around standing. And one really fascinating thing about this opinion is actually footnote 4 and the interaction between Justice Barrett and Justice Thomas about the impact of the common law, because in the Article 3 standing context, in the Spokio decision that is up essentially for quasi-review right now in this TransUnion case, there's this central component that lower courts have no ability to agree on, which is how are you supposed to decide whether a privacy violation is sufficient to trigger Article 3 standing? Well, you might look to common law, but Justice Barrett in this decision actually kind of rails against Justice Thomas and says, well, when Congress passes a statute, they mean to supplant the common law. They don't mean to match it. But what lower courts have been doing in these post-Spokio standing cases is they've been saying, well, this statute the harm in this statute doesn't look like it would meet the common law definition of libel. So therefore you don't have standing, which is totally backwards, I think, for the reason that the floor explains.
All right, a couple of more questions. Again, I think we've addressed them, but nonetheless, I'm going to pose them. Is the without authorization as opposed to exceeds authorization prong still a distinction, since insiders must apparently act without authorization to run afoul of the CFAA?
Insider acting without authorization would have to be going somewhere they're not entitled to go.
Yeah.
Okay. There's no doubt that the exceeds authorized access was intended to do something with respect to an insider. We're not clear what.
But I agree with, I actually think in the reality of the world, it actually has a very big meaning. Most of us work at organizations that have some computers we have access to and some computers we don't. And even among the computers, there are places you have access and places you don't. Any sophisticated workplace would have a part of a internal message board that is just for the executives, or another piece that's other, so
You
I
can't
think
access the payroll department, and you can't access other people. Right.
yeah, exactly. So I think it still means a lot in reality in terms of, but what it does is it does put the onus on whoever's computer it is to not just say, here, go do whatever, I'm going to give you access to everything, but you better not do this one thing that I don't want you to do. And instead put up partitions, make, it's again, the technological, I mean, the question about what a technological barrier looks like is, I think, unanswered at the edges, but in general, if your password doesn't give you access to the part of the computer where your company stores its HR, which most people who work in an organization who are not in HR don't have access to that part of a computer, then you're exceeding your access if you go over there most of the time. I mean, again, I hate to make broad generalizations, but I really don't think that, I don't think that.
Which I rent from Verizon has a password of password and a user ID of admin. And I put that in all the time to change the router settings. I am not accessing without authorization. You can look up those passwords. So it's sometimes, even if it's not your password, if you can look it up, if it's so easy or so trivial, it's not a barrier at all.
I think that's right. And this is where I disagree with my friend Oren Kerr. And that Oren likes the bright line of a technological thing. I think a technological thing is absolutely a floor. But I don't think it's the ceiling. And I also think there might even be situations in which going over a technological barrier doesn't create a CFAA problem because that barrier isn't really a barrier. And I think there are lots of, again, just, out there on the world, when I talk to security researchers, I think it's clear, again, this is the ACM. I think it's fairly obvious that port scanning has to be okay in this concept, because that is definitely it. If you find an open port, and it's admin, nah,
exactly.
I think there's a lot of area where, for those of us, for the people inside the tech, there's a lot of things that you might be able to think of that some people might think is a technical barrier, but I think people who are inside the tech would see that it's really not. And that's why I kind of started with, I think Justice Barrett's point that we need to use technical definitions when we're talking about applying things in technical contexts can end up being pretty important as we go forward. And it is why those of you on the ACM side of this, I'm going to be asking you for amicus briefs to describe how things work inside the technical, probably in cases for the next, we've had the last 20 years where I've been at EFF, probably the next 20 as well.
Alan, you're going to get pulled into this. I found very disturbing Justice Thomas's opinion, to the extent that he doesn't care that the way technology is moving has now basically embraces expanding the Computer Fraud and Abuse Act so that it criminalizes terms of service and letter prohibitions and limits of motive versus an improper motive. What I found upsetting is that it basically allows private entities and corporations to criminalize conduct that previously would be nothing more than a civil contract violation, for example. And yet, you support the government's position here And in my opinion, and you may want to clarify this, you seem to be saying, yes, it's okay to have this expansive view. If somebody says that's an improper purpose on my computer, then it becomes criminal. Am I reading your interpretation correctly? And whether I am or I am not, how are we going to address Justice Thomas's views going forward?
Well, I don't think you're reading our interpretation correctly, because we don't endorse the government's legal theory of the CFAA. And I think we go out of our way in our brief to say, look, we have a different view of the CFAA. We have supported the outcome in Van Buren for the reasons we explained. We actually drew out several factors. Again, going back to what I said before, I think most of the people talking about this case were talking about how do we limit the CFAA. And I think that the majority opinion shows that the Supreme Court doesn't really know how to do it totally in a bright line way. They don't really explain how it's going to be limited. I think that purely a technological control rule is over-inclusive in both directions. I think I agree with what Mark said earlier, that I think there are probably examples that should meet the definition of exceeds authorized access, that involve technological controls, examples that involve technological controls that don't meet the definition, and then the same flipped with non-technical controls. But the issue, I mean, the bigger issue that you're highlighting with Justice Thomas saying essentially, well, we have lots of criminal laws that can be abused, so that doesn't mean we should interpret this particular law in a particular way. I mean, I think the problem of over-criminalization is one that definitely has to be dealt with. I don't think it's something the Supreme Court is going to fix for us. And I think the problems with the CFAA, this case shows, are not ultimately something the Supreme Court is going to fix for us. Neither are the problems with a lack of adequate privacy protection in the US. So there's a lot of work for Congress to do here broadly, not just in the CFAA.
Okay, I'm going to take issue with you. I warned you that you and I were going to go head to head on this. I see a problem in that this statute was drafted primarily in the 1980s. Think back to the late 1980s. What was the internet? It was for educational institutions. It was for the military. It was for some other government research institutions. By the 90s, it was a commercial network. And today, almost everything is done on the internet. So my concern with Justice Thomas's interpretation and the way you're trying to use it as a privacy law is that you take something that was criminalized for a very narrow domain of technology, and now you've expanded it so that if I write a term of service, I can criminalize your conduct. And that really bothers me. And I have problems seeing a civil libertarian organization basically supporting some of that position.
Well, I don't agree that just by writing a terms of service, you can criminalize conduct. I mean, I don't agree with that view of the CFAA, and I don't agree with the government's prior arguments endorsing that view of the CFAA. I think that, look, the treatment of terms of service as sort of holy contracts in the law is one of the original sins of U.S. privacy law failure. I mean, it's a joke. And one of the things we highlight in our brief is that when we kind of identify some of the factors that we think courts should consider normatively, is really the degree of the control, whether technological or contractual, right? And then Van Buren, what were you talking about? It wasn't a terms of service. It was a policy manual that every police officer was trained on. There was no question about whether Van Buren knew that what he was doing violated the policy. Give me a break. I mean, the guy was essentially like taking a kickback to do a fake search. And so I don't think it's equivalent to a situation where a website just kind of throws up a terms of service and then says, gotcha, I'm going to bring a CFAA case. And the other thing that we said was, you know, I think that the law should distinguish between truly protected systems and ones that are public facing. I totally agree with that. I take issue with, again, the injunctive relief in high Q, but on the facts of the CFAA as to just, you know, the non-technical aspects, I think it's a tough case. But I do think there are ways to draw lines here. Justice Thomas mentions also the mens rea requirement, as well as the requirement that the violation be attempting to access data on the protected system, right? And what type of data I think is relevant to ask as well. So yeah, I don't think throwing up a terms of service and snagging people for running afoul of it should pass muster.
But the statute does not
Not just
require you
suing
to
people.
obtain data. It requires you to access data. It requires you to obtain information. And that's so broad that it includes learning information about how to get into a system, which implicates all the security research. If you exceed your authorization and obtain information, not download files, not read data, obtain information. So,
Eric?
Mark, I don't know if I'm speaking out of school, Andy, but I had a question for Mark, which is why is there a private right of action in the CFAA? You know, it's somewhat, in my experience, unique in the federal criminal code to give a private right of action to say, basically, any private citizen, if this criminal statute is violated, I can sue you civilly. I'm kind of curious of the origin.
because a lot of the original cases occurred with large defense contractors, and they wanted the ability to go after. Think about who had computers in 1982. The original statute was written in 82, amended in 84. Large defense contractors, government agencies, banks. That was it. They were the ones who were getting harmed. They wanted to be able to sue.
Interesting.
Okay, Eric, I'm going to bring you back to what Alan said. Do you have any opinion on how appropriate it is for, or how capable it is to limit how you would use terms of service policy manuals, other prohibitions, including banners on websites and letters of cease and desist, to limit, as Justice Barrett put it, to have guardrails on how the Computer Fraud and Abuse Act would be used?
Yeah, I think this is where the rubber meets the road. And we talked about someone's question about the distinction between without and excessive authorization. I think it's a muddy mess. I think you could characterize a lot of stuff that people are insiders as actually being without authorization and vice versa. I also think on the kind of barriers we're talking about, I also think it's very unclear. I do, in my practice, see companies use terms of service as the basis on which they bring CFAA claims. I do see companies write cease and desist letters saying, don't touch my website, as the basis for CFAA claims. And to Alan's point, and to your concern, Andy, it's not just civil lawsuits. What they will do in parallel is they will go to their local FBI office or their local U.S. attorney's office, and they will hire high-powered lawyers to pitch a criminal referral and say, we are suing this company for hacking our systems, and also you should prosecute them. And so they will encourage the government to send out a grand jury subpoena or a search warrant in certain cases. And so it is this tool that is being used by private litigants who are basically becoming effectively private kind of, attorneys general or AUSAs to prosecute these cases.
And there are 50 state computer crime statutes that were patterned after
Yes.
the Computer Fraud and Abuse Act as well.
Yes. I think that's a great open question as to how state courts are going to interpret their own state equivalents of the CFAA in light of Van Buren. There may be some kind of movement kind of against the expansive interpretation. I mean, California's is very broad, in some ways broader than the CFAA. It'll be interesting to see
very
what
few of
courts
these
do.
states provide a private right of action.
Well, California does, and it was indeed, it was,
California does.
yeah, it was the California statute that drove Power Ventures, the little company that we tried to help, who had the tenacity to offer you an opportunity to look at all of your social networking in one screen, and got sued into a smoking hole by Facebook. That's the California statute was really front and center of that.
All right.
I
One
mean, I
more
think it's
question.
important. We're here and we're talking about crimes, we're talking about criminal justice, and I really do think that it's equally important to take a look at the anti-competitive uses of this statute. It's really, they are, I agree with Eric. I think where he sits and where I sit, we see a similar thing. It is a tremendously powerful tool against competition, and we took a bite out of it with Van Buren, but the context was different enough that we still have work to do in that regard.
One more question from the audience. And this gentleman poses an analogy. When you take film in for processing, if pictures that appear to be sexual or pornographic, the film processor is required to turn that roll of film and any prints over to law enforcement.
No, he's
How is
not.
that different? How is that? I'm going to read the question, Mark. How is that different from the Geek Squad person looking at more than they have business looking at and turning someone into law enforcement if they find something? Now you can go.
Yeah, so it is not required. There is some child porn stuff where you might have requirement, but certainly sexual imagery is not required to be turned over to law enforcement by film providers, and it's a good thing.
And what idiot is taking film pictures that are sexually, that's what got invented the phone.
In the context of the Geek Squad, what we discovered, because we did a lot of FOIA, Freedom of Information Act and Public Records Act work around this situation, was that basically the law enforcement was paying Geek Squad employees to turn people in, and that is not okay on a bunch of levels. And you know, first of all, Best Buy. Anyway, so there's it's not okay. The second question, the follow-up question, the chain of custody question, I mean, I don't think that's the reason why it's not okay, because it's easy to duplicate. It's fairly easy to duplicate in either situation. But
the other problem with it is just a societal one. Forget child pornography for a minute, but it basically says that if I have anything to hide ever, I can never take my computer in for repair. And you do have the Hunter Biden issue as well, you know.
Well, and I think that gets to a point about, you know, and it's not just obviously the CFAA, as we mentioned earlier, is not the only tool that can be brought to bear on a variety of problems, but I do think that it gets to a bit of institutional design, right? So think about Van Buren. If you're this police department now, and let's say that you truly want to make sure you have an enforceable limitation on people accessing your license plate records, do you now have to build a system where you only grant like one-time access? You have to give a one-time password to access a specific license plate registry after you validate the query, right? I mean, how much do we have to build in to add in technological limitations to be able to enforce a legal protection?
I think you do what a lot of hospitals are doing, which is, you know, the doctors and nurses need to get immediate access to medical records. They can't sit there and do 5 different authentications and state their purposes and stuff. So you give the Van Burens access, but you monitor unusual activity and you bring them in, you do audits, and you say, hey, what the hell are you doing? Why is everybody that you're looking up a woman from the age of 18 to 24 who's blonde driving, you know, X and such cars? That doesn't make any sense. So you audit it, and then if they abuse it, and I do believe there could be, although there's problems with it, a misuse of data or misuse of databases statute, but the CFAA ain't it.
All right. I have a final question. And in typical Andy style, it's a jump ball. Do we need a new computer crime statute? And if we do, what should it look like? Raise your hand if you want to go first.
I delegate this to Eric.
I would have to spend a lot of time thinking about drafting that. I think that this statute can be saved with more interpretation that narrows it significantly. And I agree with Alan, or at least I agree with the intent of Alan, that there should be more robust privacy laws and not kind of a grafting of an anti-hacking statute into a problem that was never kind of meant to solve. But I don't have the words of that statute written yet.
well, I mean, I tried. It was called Aaron's Law. You can still find it on EFF's website. It didn't do everything actually that we would like it to do, but we tried, and we tried really to deal with also the really disproportionate penalties. And you know, we haven't even talked about the penalty side of the CFAA, but it is really disproportionate and doesn't recognize the difference between, you know, foot faults and major abuses. So if you want to look, that's our stab at trying to do it. And I would even, I would dig around. I think the earlier drafts, once we went through the legislative process, it got watered down quite a bit, but that's where I would start. I think that, so that's what I would say. But honestly, that's secondary. We need a privacy law. I mean, I think that all of our uncertainty and uncomfortableness about the Supreme Court decision, at least on this panel, comes down to the fact that we don't have something else that is protecting people's data when it's being held by these third parties. And I have lots and lots of ideas about how to write a privacy law. And I know our friends at Epic do too. And then we can both be on a panel and agree.
Oh, cool. And Andy, I would say this, and you know, you, Eric, and I are all former prosecutors. And I think in examining what we should say in any computer crime statute, we have to look at two things. Number one, is a bunch of stuff that we don't believe is really criminal being prosecuted or litigated under a criminal statute. And I think we all agree, yes. We also need to look at, is there stuff that is criminal that is not captured here that should be? So in other words, it's not a question of broadening and narrowing, it's making it more appropriate to deal with stuff that we otherwise agree is and should be a crime.
Anyone else? Because I'm going to make the following proposal. One of the biggest problems with this statute, as well as quite a number of other statutes that address technology, such as the Stored Electronic Communication Act, the Electronic Communication Privacy Act, is the definition of the words that are being used. The technology moves very rapidly. The law does not. And you are using old definitions and trying to apply them to new technologies. And I think that poses a big trap for the unwary. So I'm ending it at that. I want to thank all of you for participating. You're all experts in this, you're pros, and I thank you for taking the time to come join us today. And anyone who's listening, who wants to join the ACM, you know how to do it. We have a website. And I hope that you come take a look at it and you decide to sign up. Thank you very much.
Thanks,
We're in.
everybody.
Thank
This was fun.